Very good afternoon, friends. Whether you are a tax professional dealing with your clients or you are a tax professional employed in industry, all of you would in some stage be dealing with litigation under GST or notices and orders under GST. Most of the times we reply threadbare on the merits of the case and on the facts. However, it is also important for RTPs to note that rule of law has a very important place in the GST law, and while replying to notices or filing appeals against orders, one must always weigh the show cause or the intimation or the orders as per the rule of law, which is codified, I would say, under section 75 of the CGST Act. So, what are the stages of litigation under GST? First is the intimation stage. It can be the ASMT 10 in case of scrutiny, or it can be ADT stage or the memo stage in case of audit or any other procedure. Thereafter comes the pre-show cause stage in DRC-01A or the show cause stage in DRC-1, and after that comes the order stage in DRC-7, against which you file an appeal in form APL. Now, let us understand how rule of law has a significance while dealing with these procedures under GST. First of all, it is important to note that an order cannot travel beyond the show cause notice. That is, under section 75 subsection 7, it is provided that a show cause notice should have various issues and an order should be on those issues itself. For example, in case a show cause notice is in the matter of, say, 1 versus 3B mismatch, then an order cannot suddenly have a point on 2A versus 3B mismatch. Similarly, many a times it is seen that in case of ASMT 10 stage, a mere query is raised on a mismatch. However, in the show cause stage, various formats are provided and reply is to be done in that format itself. This is violative of rule of law and Article 14(19)(1)(g) of the Constitution of India and also 75 subsection 7 of the CGST Act, and may be challenged going forward. An opportunity of being heard is very important in any taxation statute. Similarly, in section 75 subsection 4 and 75 subsection 5 of the CGST Act, this opportunity of being heard is embedded. Therefore, whenever you are replying to a show cause notice or an intimation or filing an appeal, it is very important to always pray for a personal hearing wherein you can explain to the officer your facts so that justice can be attained at each level and you do not have to go to higher stages itself. Important also is for the adjudicating or the appellate authority to consider each and every point raised by you and reply filed by you and the submissions provided by you in the personal hearing stage. In case cognizance is not given of your replies or representations, then it would be violative of the rule of law as embedded in 75(4) and 75(5). Again, it is a right of the RTP to take adjournments in case there is a prevalent hardship, and as per Supreme Court judgment and as per 75(4) and 5 also, 3 adjournments should be provided by the officers even in case and adjournment is not provided, then it should be specified very clearly as to the reason why an adjournment less than 3 adjournments have been denied to the taxpayer. In case it is not done, then the rule of law would consider to be have violated, and the intimation or the show cause or the order may be considered as null and void. Again friends, section 75 subsection 9 provides that interest is payable in case a demand is payable. So whenever you are analyzing the impact of a order or a show cause or an intimation, always do analyze the impact of interest, which is always payable and cannot be dropped in case a penalty or a demand is not dropped. Next important thing is that a speaking order should be passed by the concerned adjudicating authority while confirming a show cause and while creating a demand. Now what is a speaking order? A speaking order is where each and every point is raised, the reply is given cognizance to, and sufficient reason is provided as to why a demand is getting confirmed. In case a demand is confirmed without providing sufficient grounds and sufficient calculations, then it would be considered as violative of 75(6) of the CGST Act, and such order could be considered to be null and void ab initio. Important again is to understand that order cannot be passed on a show cause which itself is prejudged. That is, at the show cause stage, a question has to be asked to show cause as to why a demand should not be raised on the allegation which is raised. A demand cannot be created and crystallized at the show cause stage itself. In case it is done, then it would be presumed that the show cause is prejudged and could be considered as violative of section 75 and rule of law. The Union Finance Minister has already specified that any communication includes show cause notices or orders from the department should be with a document identification number. In case it is not so, then the notice or the reply or the order should be considered as void. Last but not the least, a show cause or an order is issued either under section 73 or 74 of the CGST Act. Section 74 is where fraud, willful misstatement or suppression is alleged. Section 73 is where fraud, willful misstatement or suppression is not alleged. Important to note is that the time barring period under 73 is around 3 years and under 74 is around 5 years. Therefore, even in case a demand is crystallized and if it is under section 73, then the demand would be only for a period of 3 past years and not 5. Therefore, it is important that each of these terms, fraud, suppression and willful misstatement, has to be weighed against the scale of a intentional evasion of tax, that is mens rea. In case it is not proved that there is an intention to evade taxes, then section 74 cannot sustain. Therefore, it is important to weigh each and every of these three terms: fraud, willful misstatement and suppression threadbare. Important also is to note that under section 73 the penalties are milder, sometimes no penalties also, but under section 74 the penalties are very stringent at a minimum of 15%. So friends, these are the important points. You should go through section 75 of the CGST Act before filing a reply of the show cause notice or before filing an appeal, and take the various contentions into your replies and your appeals so that proper justice can be availed by the RTPs. Thank you very much for a hearing. Please do like, share and subscribe to this channel, and stay tuned. Thank you.